We're here with Gerry Shoaf at his law offices, the law offices of Redwine and Sherrill in Riverside County. It's February the 12th, 2009. And Gerry, thanks for agreeing to be part of the Colorado River Board Oral History Project.
Sure.
We appreciate it. Well, let's jump right into it. You're not an employee of any particular water district, but Redwine and Sherrill, and you specifically, have represented the interests of a number of water agencies over time. And I think we're probably primarily interested here in your representation of Coachella Valley Water District
Right.
and its relationship to the Colorado River. So let's talk about that. Maybe you could begin this interview by giving us an idea of how long you've been involved with Coachella and what that involvement is.
Sure. I joined the firm in 1971, to provide litigation backup or litigation experience. I came out of an insurance defense firm where I'd done a lot of trial work. And it was Maury Sherrill, Justin McCarthy, and Bert Foreman. And Maury was the water district guy. Justin handled condemnation actions, but most of the districts in those days didn't have much other litigation. But it was on the horizon. And Maury also needed some backup in terms of attending board meetings and doing administrative, legislative type stuff. So that was in 1971. I would attend board meetings sporadically when Maury couldn't make them and handled whatever litigation there might be. And that went along until about 1976 when Tropical Storm Kathleen hit in Palm Desert. And it was a huge storm. I think it was a 1 in 500 year event, and the runoff from that storm reaching the Salton Sea raised the level of the sea 10 inches
In just one
season,
storm. One storm.
And then the following year there was Doreen, another tropical storm that wasn't as big, but it also contributed to the rise in the level of the Salton Sea. The Salton Sea had been set aside by presidential order in the late 20s or 30s as an irrigation drainage sump, place for drainage from the Coachella and Imperial Valleys to go, because it was a low point in that entire watershed. And that's what it was used for. The reason I bring up these storms is that the farmers around the sea, primarily the Elmore family and corporation, in the late 70s filed a complaint with the State Water Resources Control Board against IID, alleging that IID's waste of water was contributing to the surface level of the sea, and that was made much worse by the storm runoff that I've just mentioned. And they asked the Elmores asked the state board to investigate and to order IID to stop wasting water, because their farmlands were either under some water or were behind levees, and the seepage from the high surface level of the sea required that they pump water out from behind the levees back to the sea so they could continue farming, and it was cost them a lot of money, and they had crop losses. So there was a long, lengthy investigation and a series of hearings, and I attended those for Coachella. As you mentioned, we are not employees of Coachella. The firm serves as general counsel to Coachella and has, I don't know for how long, Earl Redwine was the original from the firm that represented Coachella. That goes back to, I'm not sure how long. Coachella was formed in 1918. And I guess that's sort of pertinent because it was formed in part to bring in a supplemental source of supply. Farming started in Imperial in the 1870s or 80s, and in Coachella a little later, but Coachella originally had such a good and plentiful groundwater supply that it was an artesian condition there. So in probably the around the turn of the century, when farming started, that was recognized, and farming became a big deal in the Coachella Valley, and the groundwater levels went down, and it was recognized early on that they would need a supplemental source of water. And that sort of dovetailed with recognition in Imperial that they also needed a more reliable supply of water. The Imperial Valley farmers had started farming, as I say, I think it was in like the 1870s or 80s. And their main source, they have very little groundwater that's usable, if any, in Imperial Valley. So they relied on Colorado River water that was brought into the valley by a series of originally privately built and maintained canals, or at least one big canal. The problem was the Colorado River would have periods of drought, and the supplies were unreliable. They would get huge amounts of water in short periods and then none at all for a long time, and they were looking for a more reliable supply. And that effort, headed primarily by Imperial, ultimately resulted in the Boulder Canyon Project Act that was approved by Congress in 1928. Which led to construction of Hoover Dam and Lake Mead and Imperial Dam. The long and short of it is that it provided for water and storage that would assure a permanent or relatively permanent reliable supply primarily for the farmers in Imperial Valley. Well, that required contracts with the United States, which undertook this construction project, including the dams and the canal, the All-American Canal, to get the water from the Colorado River into at least Imperial Valley, and then later the Coachella branch would bring water up to the Coachella Valley off of the All-American Canal. And it also required some other arrangements, and that's because there had been a compact between the upper and lower basins, Colorado River basins. The upper basin consisting of Colorado, Utah, New Mexico, and parts of Arizona, and the lower basin, California, Nevada, and other parts of Arizona. And the compact, which is in 1922, as I remember, divided the total flow of the Colorado, as it was assumed to be, 16 million acre feet, into basically 7.5 million for the upper basin, 7.5 million for the lower basin, and 1 million for Mexico. In the lower basin, there was no agreement as to how it would be divided among the three states for a period of time. And the Colorado, and some of this is a little hazy in my mind. I haven't gone back to research it, so I don't recall the details with precision, but I think in the Boulder Canyon Project Act, Congress laid out an apportionment, and it was 4.4 million for California, 300,000, I'm sorry, 3 million for Arizona. Is that right?
No.
2.8 million.
2.8 and then 300,000 for Nevada.
For Nevada, that's right. Okay. So the California apportionment of 4.4 in turn needed to be apportioned among the California users, and so there were a series of meetings, and ultimately that resulted in a 7-party agreement. And I've never quite figured out why it was called that, because there weren't really 7 parties. But the participants included Palo Verde, which had the senior rights to Colorado River water, the Yuma Project, California side, which had some water rights, Imperial, Coachella, and those were the ag agencies, and then MWD, which included under the MWD umbrella the city of County San Diego and the city of LA. I guess that made up 7 participants, but there were only like 5 signatories. The Yuma Project never signed, and neither did the cities of the county of San Diego. So that agreement resulted in the first 3.85 million acre feet being set aside for ag use, and that was first to Palo Verde for enough water to irrigate 104,500 acres. The next second priority was for the Yuma project for up to 25,000 acres. And those aren't quantified numbers. It's just water needed to irrigate those acreages. And then the third was divided into two parts. The first part, here it gets really hazy, but I'll say basically it was to Imperial, IID, and Coachella for what was left over of the ag 3.85.
Okay.
Um,
Well,
it-
how does Bard fit in there? Bard Water District.
I don't.
You don't
remember.
recall?
Yeah, unless it's part of the Yuma project, I don't know.
Okay.
Is that California side or is that here?
California.
Yeah, I'm not sure. If I ever knew, I don't remember.
Okay.
So that was done. That was called the seven-party agreement. Then Imperial negotiated a contract with the feds for construction of of course, the Boulder Canyon Project Act authorized dams, but it entered into an agreement for construction of the All-American Canal, and I think maybe also the Imperial Dam. I don't remember if that was part of the deal or not. But that contract assumed that Coachella would be part of IID. So there'd be one huge district, both valleys. The farmers in IID, as I understand, the farmers in Coachella, as I understand it, didn't want their lands subjected to liens for this huge amount of money required for the All-American Canal and I think for the Imperial Dam. And even though the Coachella board had originally approved that approach, I say even though the board had approved that approach, well, they got recalled by the farmers, and a new board was put in at Coachella, and they elected to go their own way. And at the time, again, it's my understanding that Imperial, not Coachella, but Imperial had a lot of influence in Washington, and particularly in Interior, and resulted in an ultimatum by Interior to Coachella that said, look, either you agree to subordinate whatever interests you may have in Colorado River water, or you build your own canal. It's that simple. We're not going to do it for you and finance it. Coachella had filed a challenge. Can't remember, I think IID filed a validation action, and Coachella challenged validation of that proposed contract because he didn't want to be part of IID. That resulted in the compromise agreement between Coachella and Imperial in 1932, I think it was. The seven party was in 31. I think that was in 32. Valentine's Day, I remember that part. And by that agreement, it was agreed that Coachella would get its own contract with the feds, but it would agree to subordinate its interest that IID would have priority to the third priority waters under the seven-party agreement for beneficial use in its service area as it then existed. And Coachella would get what was left over. So that ultimately led to a problem later on when Imperial was using, and in Coachella's eyes, wasting huge amounts of water. They were diverting, I want to say, at the time, California was diverting like way over the 4.4. I don't remember the numbers, but Imperial's attitude, as conveyed to me by Paul Engstrand, their then attorney, and others, was, hey, we can dry you up. Imperial can dry Coachella up. We get first call on all the water. And Coachella was getting more and more concerned about IID's attitude and about their practice of water use. The problem in IID, as Coachella saw it, was that because it was a entirely gravity-fed system, the farmers would order water, and they had to order it like 3 or 4 days ahead to get it from behind the dam at Lake Mead down through the system and out to the fields. Well, if it rained or if they changed their minds, they would just let it run to waste. It would go directly from the delivery system into the drain system and hence to the Salton Sea. The farmers also, because the water was at that time so relatively cheap, would overorder to make sure they had enough. And then they would run what they didn't need to waste, just into the drains, either not divert it or let it run off the end of the fields. Another aspect was that the fields in Imperial Valley were huge, and they had like irrigation runs of a quarter mile. And they were fairly flat, so they would have to, in their minds, apply water for a long period of time to get even uniform application down to the root zone. So again, they were, in Coachella's mind, over applying water more than they needed if they had operated differently. Along came the Elmore complaint and the flooding issue, the Salton Sea, the drainage issue, responsibility. And Imperial, Paul Engstrand told me, we're going to make Coachella pay all those damages because your water floats on top. Yours being Coachella's water. And that was a whole interesting side issue with Salton Sea flooding cases and all of the responsibility for damages. But it focused Coachella's attention on the issue of IID's water use and efficiency.
Let me make a point here, because Paul Engstrand is the subject of another oral history that's on file with the Colorado River Board. And Mr. Engstrand was not only represented IID at one point in his career, he also represented the San Diego County Water Authority.
Yes.
Later in his career. And I just wanted to make that point on tape here in case anyone is watching.
Thank you, Jay. I had forgotten. He actually was special counsel to IID, John Carter. Before John, Reg Knox was general counsel when I first got involved. And John's dad had been involved, and then John, in the same firm, John Penn Carter, took over, and he's the one I dealt primarily with. In the litigation over flooding and apportionment of damages, Paul Engstrand was special counsel for IID, and that's how we interacted. And that's in that context, he made the statement to me that Coachella was going to pay the entire cost of damages because Coachella's water, Salton Sea, floated on top. Just as an aside, Coachella offered an apportionment, which was refused, and we ended up getting a judgment for far less responsibility than we had offered to IID to settle. But that's a whole different story. The point of this is, when all of that was going on, the damage cases went to trial. There were some settlements, a lot of activity in the Salton Sea damage area. And that all went on through the early 80s into the late 80s with appeals and all. One of the things that came out of that, the parallel or simultaneous state board hearing process, was a pitch by Met that it would provide money to IID to make its system more efficient. And in large part, that involved unlining canals to save water that was then being lost to sea beach. And the state board thought that was a good idea. And without ultimately deciding whether the IID was wasting water or not, they ordered IID to enter into an agreement with Met, which it did. That was the 1988 Water Conservation Agreement, whereby Met funded canal linings, and it got, what was it, the estimated savings, 106,000 or so acre feet per year. And then there were some adjustments, some approvals, because Coachella arguably had to approve that arrangement and so on. So all that went on. And then... So
Coachella needed... Well, firstly, let me just a point of clarification. IID, in that agreement, simply took MWD's money with the promise that they would do certain water conservation activities. My recollection is that it wasn't specific to canal lining. It could have been anything that consumed water.
That's correct.
And in fact, IID wound up with a state-of-the-art control center
Yeah,
for moving water around that was largely, if not entirely, paid for by MWD. So anyway, just a
that's
point
a
of
good point.
clarification.
That's a good point. I don't remember all these details to that level.
But in that agreement between Metropolitan and IID, and I'm going to bring you back to where you just came from, Coachella needed to be in there. They needed to be a party to that. Why?
Because of the conclusion on Coachella's part that any water that IID was wasting was illegal. I mean, they had no right to it, and therefore conserving it was a legal obligation they had. And by conserving it, they should have left it in the system or in the third priority for Coachella's use as junior partner, rather than have the right to transfer it to Met or anyone else for that matter. Coachella said, yeah, you don't have a right to waste. You have a legal duty to stop waste. And if you stop waste, the water that's saved thereby belongs to Coachella as a junior partner. And that carried over then in the mid 90s to the proposed IID San Diego agreement, whereby San Diego wanted to buy conserved water from IID, what they called conserved water. Well, that focused Coachella's attention on the problem because here we got the third priority that's not quantified. IID doesn't have a fixed entitlement. It gets whatever it can put to quote beneficial use. Well, it could claim in Coachella's eyes, IID could claim to be conserving water. It could transfer the water it claimed to conserve to San Diego Met or anybody else, and yet continue to use the same amount it had been using all along for its own purposes. And that led to a lot of angst in Coachella in light of the attitude by some at Imperial that they could dry Coachella up and use all the water and transfer what they wanted and so on. Well, the San Diego proposed agreement, I think, triggered the discussions somewhere, and I don't remember where all this fit into the timeline, but at some point, John Carter approached me at an NWRA conference at Hotel Del Coronado. I think it was in the around late 80s or 90, suggesting maybe we should try to quantify the third priority. That was the topic. And that led to a series of meetings and negotiations between the two. Tours were had in Imperial with Don Cox hosting us, and then tours of the Coachella Valley where we hosted Don and the other, I can't remember who else. Lloyd Allen was a committee member at one time. And we came to understand each other's positions quite well. And from Imperial's perspective, they weren't wasting water. Their water use, the way they used it, was necessary to irrigate in the way they had. That was interesting because in the context of the flooding, the hearing on the complaint, the Elmore complaint, the attorney for the Elmores, now I may be mixing this up, Skip Sutherland represented the damage claimants in the litigation for Salt Sea flooding. Skip had carousel after carousel of slides showing IID's drainage system and their wooden gates they would use to check up the drains. They just leaked like sieves. So this water didn't, instead of being held in the system, was just running through the gates into the drains and into the Salton Sea. He had hundreds and hundreds of those slides, hundreds of gates, tailwater boxes that are designed to measure return flows off a field at the bottom of the field before it entered into the drain. So they know how much was going off the field. And they could calculate from the deliveries how much was being put to beneficial use and so on. There was some huge percentage, I want to say 40 to 50% of those tailwater boxes were inoperable. They were broken, they were filled with dirt and debris. They just couldn't be used for the function that IID claimed they were being used, which was to measure runoff so as to get a handle on the efficiency of water use. They just couldn't do it. They claimed they were doing it, but from our perspective and the Elmore's perspective, it was not possible to be done with any degree of accuracy. So we got the issue of waste floating out there, and IID's claims in these negotiations that they weren't wasting, and Coachella's claims they were, and along comes the San Diego proposal, and I don't remember exactly how it all came about, but it activated negotiations or caused negotiations between IID, Coachella, and Met. San Diego wasn't directly involved in those because it wasn't a Colorado River contractor with the feds. But the particularly Maureen Stapleton elbowed her way in and made it clear that by God they were going to be present at the negotiations. If they didn't have a vote, they were sure going to let people know where they stood, and that's what happened. And San Diego was ultimately protected in the QSA agreement. And the Bureau at one point threatened to reduce IID's diversions out of concern over the beneficial use issue. And they may have more than threatened. I don't know if they actually carried it out, but IID sued the Bureau in federal court. And that was either triggered the actual negotiations or it was operating in parallel with the QSA negotiations. The sequence fuzzy in my mind.
Is beneficial use a federal issue or a state issue?
Well, it's a federal issue as well. They're only entitled to as much water as can be put to beneficial use under, I can't remember, I think it's both statute and case law.
Okay, but
Federal.
But the word beneficial is not well defined anywhere.
No, it's not. It's not. But the long and short of it was the negotiations that led to the quantification settlement agreement were, if not caused entirely, were certainly spurred on by the San Diego proposal and or the Bureau threat or actual order reducing IID's diversions. Because IID was, as I mentioned earlier, I can't remember how much they were using this 3.7, 3.8 million acre feet. They were diverting. And it was felt by everybody else on our side of the table that was way more than they could ever possibly put to beneficial use, considering the 400 and I can't remember how many acres they had, 450,000 acres to irrigate. So those negotiations went on a regular basis from 95 or 6 until the ultimate agreement was signed in late 2003. So it went on a long time. And they were held in D.C., they were held in Denver, they were held in San Diego, they were held in Riverside, they were held in L.A., just moved around wherever people could accumulate. And they were hosted primarily by various DOI personnel.
I think David Hayes was.
David Hayes was the last one. The state got involved. Who was the Speaker of the Assembly? Hertzberg.
Mm-hmm.
He was involved heavily at one point. Richard Katz was involved heavily at one point.
When you say the agreement finally was signed and we're talking about an early 2000 date, you're really talking about the quantification settlement agreement, right?
Yeah.
Let me take you back before that, though, because we've already discussed in some measure the IID MWD transfer, which predates the QSA,
Mm-hmm.
and the San Diego Water Authority IID transfer, which maybe was a precursor to the QSA, but
Yeah.
set that aside for a minute. The question is, what did Coachella Valley Water District want out of those discussions, and what did they get?
Coachella wanted and needed a a baseline imposed on Imperial, so that if it was going to transfer, as was being proposed to San Diego, whatever it transferred would come off of its baseline, so that it would not be able to say, hey, we're conserving and transferring and still continue to use the same amount of water they've been using all along. Using the what water Coachella believed had been wasted up to that point and therefore not needed for crops in Imperial Valley. They'd transfer that waste and still get the amount that they had been using, and there'd be no net change for Coachella other than a reduction in water available for its use. So it needed a quantification of the third priority, and it needed enough water to continue in the foreseeable future for operations in the Coachella Valley as well. And what resulted from the QSA was an agreement by IID to limit its entitlement to 3.1 million acre feet, and off of that number would come the transfers that it had made earlier to Met under the Water Conservation Agreement in 1988, the 100,000 or so. The water proposed to transfer to San Diego, the 200,000 acre feet or so. And under the QSA, there were some other transfers. It agreed to transfer, actually to sell water to Coachella in two chunks, a 50,000 and a 53,000 chunk, each involving a different ramp up and a different payment amount. So it limited its share of the third priority. Coachella was given a quantified share of the third priority, 330,000 acre feet. It also ended up with these arrangements with Imperial for additional amounts, 103,000, and by some other agreements with Met. I can't remember the numbers. I think it was another at least 35,000 of Met's state project entitlement, and in return, Coachella gave Met an option on the waters transferred from Imperial, and so on. The net Coachella ended up with was about 456,000 acre feet if it needed it, and was willing to pay for some part of it. But it had that contractual entitlement, a base quantification right of 330,000 of Colorado River water, and these other contractual options / entitlements that brought the total up to 456,000 after it was held responsible for some other amounts, like the canal lining water went to Met and so on. But that was Coachella's net.
And how does that 456,000 of available water compare to what they wanted going into the negotiation? Was that good? Or?
Yeah, it was very good. Very good. They hoped to come out with, at the time they were using, and they're still using about 330,000 for ag, as I recall. Plans are afoot to start using that water, and they are to some extent using that water for golf courses, to get the golf courses off of groundwater, which is very high quality, and it's overdrafted, but there's a ton of it, a lot of water. It's a huge basin. And ultimately, they may be treating that water for domestic uses as well, that being the Colorado River water.
For the sake of those people that may not be familiar with the geographic boundaries of Coachella Valley Water District, could you describe those? Because you just mentioned golf courses.
Oh, sure. Basically, it's from the Whitewater River on the west end or upper end of the valley, and it's bordered on the north by the San Bernardino Mountains as they trail off into the Chocolate Mountains and so on the northeast side of the valley. And on the south side, it's the Santa Rosa Mountains. Then it goes on down around the north end of the Salton Sea on each side, basically to the Imperial County line, Riverside County, Imperial County line, and in some areas protrudes into Imperial County, primarily on the east, what I call the east side of the Salton Sea, and it actually extends into San Diego County, in an area that there's no service. I'm not sure exactly where that is, but
Okay. So basically, in terms of metropolitan areas, then we're talking Palm Springs, City of Palm Springs,
Does not
Coachella.
include the city of Palm Springs.
Okay.
It basically starts at it covers the coal communities. It has facilities for recharge that are in the Palm Springs area, but the city of Palm Springs itself is part of Desert Water Agency service area. So Coachella goes up to the Whitewater, where the Whitewater enters the valley, and it goes over toward Palm Springs and then curves around Palm Springs and picks up the cove communities, which start with Cathedral City, Rancho Mirage, Palm Desert, and Indian Wells, La Quinta.
Okay. Some very important tourist areas in
Oh yeah,
California.
oh yeah. And there are presently, I think, 120 golf courses in its service area. That is the premier economic engine now. I think, I'm not sure of this, but I think it's, if not larger than, certainly approaching the ag economic engine in terms of production, money production. It's huge. So it's a very important factor in the economy in the valley. And that number of golf courses use a lot of water. And the point is to get them on. And Coachella is serving some with recycled water. I think most recycled water that it produces through its regional plants is put to use, not discharged. But there's not enough for all the golf courses, and the facilities aren't all in place. But the thought is that it would be easier to use Colorado River water, and it is currently building what's called the Mid-Valley Pipeline to take water from the canal into the upper valley where many of these golf courses are. So as to be able to use Colorado River water for those golf courses in place of the higher quality groundwater.
So the groundwater withdrawn in Coachella service area is better quality than Colorado River
Yes,
water.
much higher, much lower in TDS, much higher in quality.
That's
Very old water.
interesting. You mentioned this in passing. Let's talk about it a little bit. Coachella Valley Water District has a contract with the state of California, the Department of Water Resources, for an amount of water, as does Desert Water Agency, but they have no physical pipeline to get that water, and therefore they entered both of those entities, and we can just talk about Coachella, but both of those entities entered in an agreement with Metropolitan Water District to do kind of an exchange. Can you talk about that a little bit? Why was that decision made? Why did Coachella opt to do the exchange rather than building a pipeline to capture their state water project water? Was economic decision, political decision?
I think primarily it was an economic decision, at least at the outset.
I'm sorry, and we're going back to roughly 1970, 71?
Yeah,
72.
actually, I think the thought started earlier, probably in the 60s. Well, it wasn't long after the state contracts were signed by all three, at least by Coachella and Desert. But the thought was, Coachella and Desert's minds, or at least Coachella's, it was a good thing to secure a portion of state project supplies to have alternatives to the Colorado River supply. I've never read or seen this is anything that documents that. This is an assumption on my part. But the cost of building the pipeline was prohibitive, or thought to be prohibitive. So the arrangements were made with Met, and I don't know the genesis of those arrangements. Maurice Sherrill worked on them, was heavily involved in it, but I just don't know who started the discussion, who came up with the idea. But the long and short of it was a very good idea, since the MWD Colorado River Aqueduct crosses the Whitewater River at the north end of the Coachella Valley. It was a natural transaction for Met to take the Coachella Desert State Project entitlement and provide a like amount of water from a turnout from the Colorado River Aqueduct into the Whitewater River, where it would flow down into what Coachella ended up constructing as a series of percolation basins at Windy Point, which is sort of like northwest, immediately northwest of Palm Springs. At the head or upper end of the Coachella Valley and of the groundwater basin underlying the Coachella Valley. So it could take a like amount of Colorado River water for what it gave up from its state project entitlement to Met, stick it in the ground, and be able to pump it out. And that has served both parties very well, I think, for what, at least 40 years. And currently, however, Coachella and Desert and Met are heavily into an investigation to extend that. Let me back up. In the meantime, the state project pipeline has been extended from Devil's Canyon east into Beaumont. And now Coachella, Desert, and Met are looking at the possibility of expanding that even further down into the Coachella Valley, or running a separate line from Devil's Canyon to around the high end, around through Morongo Valley, down into the Coachella Valley. So that investigation is underway. And even though it's very costly, the value of the water is seen as, and the ability to pay through the customer base is seen as now something that's feasible, pay the cost of that project. So that's what's going on right now.
And just for the record, Devil Canyon is located on the northern border of the city of San Bernardino,
Right.
roughly up in
Yeah,
the foothill.
below Lake Silverwood, which is a state project,
Reservoir.
forebay or whatever you call it, into the pipeline distribution system onto Lake Paris and points west and south, I guess. Can we take a break?
Absolutely.
I would like to take a break.
We're back from a quick break. And Gerry, you had mentioned, before we started taping again, you had mentioned certain power issues that emanate from water in the Colorado River, and some accommodations that were made, or concerns that Coachella had with respect to power produced by falling water in IID, and there was a big money issue. Can you walk us through that negotiation and ultimate settlement?
Well, I'll try. The compromise agreement that I mentioned earlier between Coachella and Imperial, that was generated by Imperial's proposed contract with the United States, which included in its proposal Imperial, the Imperial service areas, including Coachella Valley as well. That compromise agreement involved the allocation of power proceeds generated from the drop structures on the All-American Canal. And I don't remember the exact percentage. It was determined that Coachella's flow in that canal represented like 8% or 12%, one or the other, I think is true, of the total flow, and therefore it should have a right to 8 or 12% of the net power proceeds generated from those drop structures, falling water. And the compromise agreement called for the two agencies to enter into a formal lease specifically addressing the power revenues and the lease arrangement, and it was to have been for 100 years. So the compromise agreement got signed, and each party went ahead with the water supply issues, but my understanding is that Coachella started asking IID for the lease, and they were never willing to sit down and talk about it. And so literally decades went by, and it was under Tom Levy's watch when Bob, who's the guy from the Bureau that was IID's general manager for a time, started with a C, I think. Anyway, he wrote the letter back saying, pound sand, we're not interested in a lease. And the reason that discussion was being held, or Coachella was pressing for a lease more recently, this would have been in the 90s.
It wasn't Chuck Shreves, was it?
No. It was Bob Mick. I can picture him. I can't think of his name.
Well, okay, it'll
Yeah.
come to one of us.
The reason that it came about was that IID had used an accounting approach in determining net power proceeds, and Coachella was supposed to get a percentage of the net power proceeds, not just generated by the drop structures on the canal, All American Canal, but from all power sources, including geothermal, and I don't know what else Imperial had, but I don't understand the reason why they agreed to that broader base of percentage, but they did. Their accounting methods generated very little revenue to Coachella because they would write off things. They included, among other elements of deduction to get to the net, the damage monies they paid out in the Salton Sea flooding cases, and all sorts of, we thought, improper accounting approaches. So ultimately, Coachella filed a suit against Imperial, asking two things: asking for three things: an accounting, asking for the money that Coachella thought was owed it under a proper accounting approach down through the years, and asking that the court direct Imperial to reform its accounting procedures to use a more standard approach so that the past would not continue to happen, the past approach. And that case was very big and very complicated in terms of discovery and looking at books and checking accounting methods and numbers. And my partner Gary Reddish handled it directly for Coachella. We had outside law firm from Los Angeles, Hill Farrar, and somebody actually do the trial work on it because it was beyond our capabilities. And it came down to Imperial trying to get the case thrown out on a statute of limitations basis, and the court basically finding that Imperial was acting as trustee for Coachella, and I wasn't that close to it, but the long and short of it was Coachella ended up getting a judgment against Imperial for, I believe, was $16 million and change. Imperial appealed the judgment. It was upheld on appeal, and they ended up paying it off just recently in late 2008. And I think the total paid was maybe $23 million, 22 or 23 million.
And that agreement goes forward.
That agreement goes forward. And frankly, I don't recall whether the judgment and or the agreement resulted in any significant change in the accounting practice. My understanding that it did not. So we may have the same problem.
Might be back again.
Yeah, we might be back again. I don't know.
Over the long term, speaking of litigation, over the long term, Coachella, at least in the 70s and 80s and maybe the 90s, had a reputation for being extremely litigious, more so than most other agencies. Firstly, and keeping in mind that you're counsel for the district, but firstly, is that characterization deserved? And if so, or maybe even if not, how did they earn that reputation, whether it's deserved or not? Did it have something to do?
I'm pausing because I'm trying to think. First of all, I was aware of a reputation for threatening litigation.
Maybe that's more. That is perhaps more accurate.
Yeah, I don't think we ended up filing a whole lot of litigation, but the threats were the result of the need to get attention from MWD and from IID, who looked upon Coachella as I don't mean to be facetious, but like a third world district out there in the hinterland somewhere that didn't count for much. Size wise, it's about water use size, about 1/10 the size of Imperial, and God knows what it is in relation to Met. So, even though it's big geographically, 1,000 square miles, and has a pretty significant economic base out there, in comparison to the other two, it wasn't in the same league. But it desperately needed to pin down its water rights, and it wasn't being heard. The folks at Coachella didn't think, and it wasn't just Tom Levy. It went back to Lowell Weeks. He was not a shrinking violet when it came to getting his message across, and Levy inherited that attitude from Lowell Weeks, in my opinion. Levy was not a forceful person before he came, or in the early years with Coachella, but he learned at the knee of the master Lowell Weeks that if you want to get your message across, you need to take action to see that happens. And the threats of litigation were one way to do it. I don't recall that we ended up having to file that much, but we certainly made it clear that we would, if necessary, to both Met and IID.
Okay, well, that's very good. Over the course of time that you've represented, or the firm has represented Coachella, are there any other contentious issues that have arisen from time to time that were resolved, or is the Imperial Metropolitan Water Transfer wastewater? I mean, is that really the major event that's been going on?
That was the major event. It went on for a long period of time, and times have changed. It's really interesting. A lot of the farmers in Coachella also farm in Imperial Valley, and many of them also farm in the Mexicali Valley. So you've got this more global attitude toward these water issues, including the Mexican entitlement issue and the canal lining and all of that stuff, because economic interests are affected on a different scale than they used to be when you had guys that just farmed in Coachella and guys that just farmed in Imperial, and each didn't think the other was doing the right thing, and so on. It was really interesting thinking back to hear allegations by Imperial of water waste in the Coachella Valley, where the if not the entire, well, it's not the entire area, but a very large percentage at that time was irrigated by drip. That didn't include the dates at that time. They were still flood irrigated. I think even the dates have converted to drip in large part now. Meanwhile, Imperial, they were growing Sudan grass and crops, a lot of alfalfa crops that were high water use crops, and they were running it off the end of the field. But they're pointing the finger at Coachella saying, well, you guys are wasting more water than we are. It just didn't make any sense. But those are some of the side things that were going on. Interestingly, all the while, it was all a business argument. I mean, everybody got along just fine, one-on-one. I mean, when we met, they were pleasant gatherings. Don Cox, Lloyd Allen, the old board, they were great guys, and the managers were tough as nails, but they were it was fun. It was fun dealing with them.
Bob McClellan, by
Bob
the way.
McCullough. Yeah. Thank you.
That's for anyone watching this. That's dating back to a name search that we couldn't do about 10 minutes ago. So.
Yeah. Gee whiz, McCullough and Mike Clinton and Chuck Shreves, and I can't remember the guys that preceded them when we first started. I could picture them, just can't think of their names, the managers. Not coming to me.
Okay, well, that's all right. By the way, was Coachella, let me recast that question. Palo Verde Irrigation District, which has the #1 priority for ag water, from the Colorado River in California, they have entered into some fallowing agreements with the Metropolitan Water District in recent years. Coachella's okay with those? I mean, did they get something out of that deal as well? Because that, I mean, in theory, if PVID isn't using the water, it would roll to IID, and then IID couldn't use it, so it would roll to Coachella.
It seems to me that that was an open issue that was ultimately resolved by getting it quantified right. Coachella got its rights quantified, so it no longer has an interest to pursue beyond its own rights. What Palo Verde does, passes water through. Coachella has to agree to it because, and I don't recall any whether that's specifically addressed in the quantification settlement agreement. It should be, it probably is, but.
Okay. Well, so the bottom line, though, is that at one time Coachella took whatever drippings were left at the end of the day,
Yeah.
and now they have a quantified amount of water, and they
That's
don't
right.
need to be concerned. Is that a
Yeah.
fair characterization?
It is. All I recall is that was an issue with Coachella, whether Palo Verde could pass water through Coachella to get it to men. And Coachella's position was, no, we can claim that water. And there were, I don't remember if there were side agreements or discussions and were underway as part of the QSA. I just have no specific recollection of that issue.
Okay. Is there anything else we should cover that comes to your mind?
Yeah, I can't think of anything related to the Colorado River. It's been an interesting ride. And I think it was resolved as it needed to be. And hopefully if the challenges to the QSA are ever fully and finally resolved, as they are now scheduled to be, it'll go on for 75 years, and what happens at the end of that 75 years is going to be interesting. I won't be around to see, but it'll be interesting.
Incidentally, just for the record, I jotted a note here down. You made some specific reference to a Valentine's Day event in 1931, very early in this interview, and I just want to point out you weren't there.
I was not. That was at 32. It was a compromise
32,
agreement
okay.
between Coachella and IID.
And your knowledge of that is based on research and whatnot,
yeah.
rather than having been there.
That's right.
I know you're not that old.
No, I said I remembered it. I remembered it. The date stuck in my mind from reading the date in the contract, in the agreement.
Okay. Well, excellent. Gerry, thank you very much for your time today, and we appreciate it. And this has been a terrific addition to the oral history series.
I hope so. It's an interesting topic and one I haven't thought about for some time now because, as you know, Steve Abbott has taken over all of this stuff and it's greatly lightened my load. As the entry into the QSA, of course, freed up a lot of my time when the night got fun.
Thank you very much.
Okay.